Michigan's got a new court ruling recently. uh, to be honest, it was just in August where they have decided to define clones as plants. And I kind of got a problem with this, but I guess it's not a big deal. It's just a matter of it seems like you're always going to have too many plants as soon as the clones are ready, and then it's like a hectic day where you just got to get the clones and get them out of your house, get them out of your operation before they can come and count them. So anyway, I'm going to refer to an article by Matthew Abel called "Defining Cannabis," and this individual, Matthew Abel, I've been an admirer a long time. He has been a very outspoken advocate for legalizing marijuana in Michigan most of my life. I've noticed him around. He's in Michigan. We have this thing called the Hash Bash in Ann Arbor, where it's basically a legalized marijuana rally every year since 1971. Um, and overall, Matthew Abel's just been there to speak and rally the troops, and he's been behind the scenes. He works marijuana cases, and he helped write laws. He helped write, proposals for laws. He's one of the activists that I do actually pay a lot of respect to. So that aside, we're just going to run through the article, and we're all going to cry together as they count every single plant at your grow op. Now, there used to be theories about what plants they could count and what plants they couldn't count, and no one really knew for sure. And then some court cases started coming in, and then, now I'm going to get back with this on this later, but there was a Supreme Court ruling at one time that defined clones as part of this unusable material in the law. It's a little confusing, and I don't really think that it really means that unless it just specifically said clones. So let's read his article, because he's going to give you a little extra insight from a legal perspective as a lawyer, as he lays out the finer points of this case. So here we go. The Michigan Court of Appeals issued a public decision August 16th in an appeal from another cannabis prosecution in the case of People versus Lorenzo Enrique Ventura. Quote, the case presents an issue of first impression in Michigan, namely what constitutes a marijuana plant. More specifically, we must determine at what point does a cutting from a mature marijuana plant that is placed in grow material become a plant itself that may be separately counted as a plant for the purposes of determining how many plants defendant had in his possession. So they're not trying to define plants in terms of how many plants, in a general sense. They want to know exactly when they should start calling it a plant. And my argument again is, on the ground and in the actual operation, that you have to have a lot of clones to continue to propagate crops. But when the time comes for your clones to be like, okay, my clones are ready to be called plants because I put them in a Dixie cup and they started growing again, I'm not sure. We're going to have to get into that more specifics later, because this doesn't really cover that. So Mr. Ventura had appealed from the guilty verdicts and also lost there. Those convictions now stand pending unlikely review by the Supreme Court in Michigan. Ventura had the right to grow 24 plants. There was 21 undisputed plants, and then there was 22 clones. The court cited under a federal case from 1993, U.S. versus Edge, which said that a cutting is a plant, and then it held that any cutting with a leaf stem and readily observable evidence of root formation is a plant. So as soon as you can throw it in dirt, they're going to count it. Now, my argument against this theory or this logic of counting plants is that you're definitely not going to grow those all out to maturity. So in Michigan, you're allowed to have 12 plants plus 12 plants per patient if you're a caregiver. And the thing that holds me back on that is that just take one person, 12 plants. So you're saying you can have 4 clones, 4 veg plants, 4 flower plants, and 4 more flower plants is how most people would probably work that out if you wanted to have a continuous crop system. But the day that you want to have those 4 clones that are actually called clones because they're in cups and they're counted as plants, you're going to have a lot more clones because you had to grow a lot of clones to make sure that you had those clones, even if it was just like 12 or something. In this guy's case, there was only 22 unaccounted for plants. Well, the 22 clones gives minus 3 more of those, and you're at 19. So he had 19 plants that were over his 24 plant limit. Now they're citing this federal case from '93, U.S. versus Edge, and I find that a little bizarre too because I'm guessing that wasn't a medical marijuana case. It might have been. I mean, anyway, Michigan is a plant count state, Abel goes on to write, and every plant counts. I guess that's just what you got to know, and now they're telling you what constitutes a plant. Careful care growers should make sure not to exceed their limit regardless of the size of any plant. Cultivators also should be in compliance with all the Section 4 criteria, including cultivation only in an enclosed area, locked facility, which, if outdoors, must comply with an additional vague requirement to have the garden enclosed on all sides but the base with chain link, wood slats, or similar material. A grower would be well advised to use chain link or chicken wire or something as a top. Why a top, you ask? There was no discussion about any actual need for a top at the time that the amendment was passed by the hostile Michigan legislature, and the issue remains a matter of dispute several years later. Some cynics believe that the provision was drafted that way to allow police to use ambiguity to raid, arrest, and charge outdoor growers who don't expend the extra money necessary to satisfy the vague statute. When harvest time arrives, it's not unusual for a seasonal outdoor grower to expect to exceed the Section 4 permitted amount of usable marijuana. A caregrower in Michigan is allowed to possess at any time only 2.5 ounces of usable material defined as dried leaves and flowers for each patient for whom they are a caregiver. If an entire harvest is dried at one time, the caregiver may need to be able to justify that amount of dried leaves and flowers. No, not just the bud, but the shake too. Stuff that's later turned into concentrates or whatever. The affirmative defense under Section 8 of the MMMA would allow a caregiver to possess an amount which is no more than reasonably necessary to assure an uninterrupted supply of cannabis for the patients served. In addition to the difficulty of justifying the quantity and annual use of specific patients, prosecutors often refuse to agree to the automatic validity of medical cannabis card as proof of a bona fide physician-patient relationship. And all throughout the legal system, whether you're talking about probation officers, judges, cops on the scene, child protective service people, anybody that's in the government will, almost every time I've heard people talk about they've had a run-in with any of these agencies, every time they will ask for some kind of a further note from a doctor explaining why they feel like they, like as if the whole process of getting the doctor recommendation never even happened. Well, that's the only way you can get a card. But every time they want to say, well, we don't think this is proof that you actually have a bona fide patient-physician relationship, or we don't see how you was actually recommended for medical marijuana and all this. And that's pretty much a common thing that Michigan patients and caregivers alike have been facing since this law was passed in 2008. And quite frankly, it's ruined a lot of lives to nitpick at a law that was originally intended to basically make it so that, compassionately speaking, if you're using marijuana for medicine, or if you're growing marijuana medicinally for you or your patients, then you're exempt from marijuana. Like this stupid thing that they invented, this name marijuana that they invented to demonize a plant and act like it's some kind of a criminal activity to be involved with it. That's what we were going against. I mean, this doesn't nullify, actual marijuana laws to the cops. Like if you don't have a medical card or whatever, of course they're gonna give you the charges. So anyway, let's finish this off. The third element of Section 8 is that cannabis can be used only for medicinal purposes. The quantity issue should be thought out in advance so that a productive grower can make sure to be able to account for all the usable product on hand. In theory, a seasonal grower might be able to flash freeze a plant, blah blah blah. If we could just legalize that, nobody would have to go to jail for a plant. Yes, I know. We can't freeze plants for later on processing, and even if you did have plants in your freezer, I'm sure they'd count those too. And they weigh everything. They weigh stems if it's in a pot, and I don't know. They used to weigh the dirt. So anyway, my take on that whole thing is well, that's just what you got to do is you got to know exactly what the law is before you operate, because you never know when they're looking at you or when they're investigating you or whatever. I don't know if they're investigating me. Hell, I make this news channel here, and that would give them a reason to be mad enough at me to maybe investigate me. I don't know. I hope that's not the case. But all I'm doing is informing people about what's going on, and I hope more people know about what's going on. Now, in this situation here, you need to know the law, and apparently the law is, I'm a producer of clones just because when the day comes when I know I'm planting all the clones and they're going to be counted as plants, I'm pretty much putting all the extra ones aside and getting them gone. I got to get them gone. I've been like that since I started this, and I'm not going to tell you exactly when I started growing marijuana for medicine, or even for myself as a person that was into a hobby, and I call it medicine back then too, because when I first started studying marijuana, one of the first things I read was The Emperor Wears No Clothes by Jack Harris. So immediately you come into it as a little kid that just read a book about how hemp was demonized and marijuana was made illegal, and then all the medicinal values and medicinal uses for it. But the whole time, every time I got, a whole bunch of cups sitting in front of me with green plants, my first thought of is this has to go. Because back in the day when it was illegal to grow marijuana flat out and you couldn't even, none of this medical marijuana stuff was going on, there was like a federal plant count limits. And the feds, the DEA in agency itself wouldn't ever get involved in your case if you had under 100 plants. That was known. But it was also known that if you were, maybe looking like you were doing too much business or something, plant count was one of the ways that they could push that investigation towards the feds. Like if you're just growing like 30 or 40 plants outdoors and guerrilla style and they only find like 20 of them, then they come to your house and you got 100 clones, it's a wrap, man. They call them the DEA on you. Other than that, I want to get more details on the specifics of this. So I've heard basically if a plant is in a cup and it's growing, it's a clone, it's counted as a plant. You have 12 plants per patient, 5 patients maximum, 72 plant maximum. You can get a lot done with that. Just grow bigger plants. That's what I always say. It's not how many plants you got, it's how big of them and how many lights you got and how you use your space and how you use each plant and how much stuff from the plant you use.